Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Canada's been banning more and more single-use plastics, things like shopping bags and straws and so forth. And you may have seen in the news a case just came out that declared this to be unconstitutional and struck down this ban. And you might be getting really excited thinking, oh my God, I can go to the drive-thru and drink a beverage through something that doesn't taste like a rolled up newspaper. Well, not so fast. I'm going to explain why this is a really important case, but also why it won't have the effects that maybe you might get the idea from if you've been watching the news. So this is the case of the Responsible Plastic Use Coalition and a bunch of others, basically against the government. So let's have a look and we'll take this one apart. I'm going to try to slim it down so that we're not reading the whole case, but just the key bits here. So this is an application for judicial review, which means that they're challenging a government decision of the federal government's decisions relating to the addition of plastic manufactured items, PMI, to the list of toxic substances in Schedule 1 of the Canadian Environmental Protection Act. Subsequent to the initial hearing of this application, Schedule 1 was repealed and reenacted with all of the same listed substances pursuant to Bill S5, the Strengthening Environmental Protection for a Healthier Canada Act. And you can tell that this is BS because of that title. Anyway, so this is the main reason why this is not going to have all of the effects that you might think it would, because after they brought this challenge, they canceled this law and then reenacted it in a different law. So this challenge then becomes a little bit, it's now missing the target, essentially. This is the sort of maneuver you can only pull when you're a government. All right. Although this application involves the order defined below that enabled PMI, so plastic manufactured items, to be listed on Schedule 1 as it existed pre-enactment, for reasons set out below, I find that the remedies arising from this application nonetheless remain of value to an existing controversy between the parties, and that the amendments under Bill S5 have not rendered this application moot. So what does it mean when something is moot? Mootness is kind of an interesting legal concept, and it's basically that courts only entertain cases that have some real value, where there's some controversy that's still live. And there's a lot of reasons for that. They don't want to waste judicial resources on entertaining hypothetical questions. And also the notion is that people who have real skin in the game and are really interested in the outcome will litigate things fiercely and challenge them vigorously, whereas somebody who doesn't actually care what happens probably won't. So you don't want things to be run by people who just have no stake in the game, because they can just be like, I don't care if I lose. And then society suffers for that. So the applicant, Responsible Plastics Use Coalition, is a not-for-profit corporation comprised of companies from the plastic industry who do business in Canada. The applicants Dow Chemical Canada and Nova Chemicals Corporation are chemical and plastic resin manufacturers and distributors, and the applicant Imperial Oil, by its managing partner Imperial Oil Limited, is a manufacturer of petrochemicals from which plastic resins are made. Now, if you're thinking that all of these names sound familiar, I'm pretty sure this is the cast of villains from Captain Planet. All right, carrying on. The applicants raise two challenges in this application. First, the applicants assert that the order adding a toxic substance to Schedule 1 to the Canadian Environmental Protection Act, registered on whatever dates, was unreasonable, as it was not a proper use of the Administrator in Council / Governor in Council's authority and does not comply with the statutory scheme under CEPA. So this is an example of the trend that we've been seeing with this government, that rather than passing bills, they really like using orders in council. And so they really like to do a lot of this stuff through these kinds of methods. This is similar to the method used to ban the AR-15 and a ton of other firearms in Canada. And this essentially is a method by which the government can exercise a lot of authority without a tremendous amount of oversight. But there is some oversight in the form of this challenge. So They contend that the listing for PMI, plastic manufactured items, is too broad, that PMI is not a substance or class of substances that could fall under the list of toxic substances in Schedule 1 of CEPA, and that the proper scientific analysis and risk assessments were not completed to demonstrate that PMI are toxic. Now, when they say it's not a substance or a class of substances, what they're talking about is like a substance could be something like lead. Lead is a substance. Or, one particular kind of plastic might be a toxic substance. But when you're just saying all plastic, maybe not. So that's kind of their argument there. Now, there's a bunch of other arguments that I'm going to skim over because we're going to focus on the key bits just for time. Second, the applicants, the Attorney General for the province of Saskatchewan and the Attorney General for the province of Alberta, argue that the order is unconstitutional. So Saskatchewan and Alberta waded into this fight because they said, listen, this actually violates our powers as provinces. And the provinces, which for the American viewers, that's sort of the equivalent of a state. The provinces have certain powers that are given to them by the Constitution, and they're saying these powers are ours, and that this move here is the federal government stepping on them. So this is really kind of the equivalent of a states' rights argument. So they say they assert that it falls outside of the federal criminal law power. Saskatchewan and Alberta participate in response to a notice of constitutional question issued by the applicants. So they're saying, we want to challenge the constitutionality of this. Now, the respondent is the government, and the respondents assert that the order was reasonable. They argue that the only administrative constraint on the governor and council's ability to make the order was the statutory scheme of CEPA. So basically, we can do what we want. And the governor and council acted in accordance with their power under CEPA and its overarching purpose. The respondents assert that Canada's trade agreements are irrelevant and outside the jurisdiction of the federal court on this application. The reason why the trade agreements were raised is that this was suggested as an interpretive aid by the applicants. All right, now I'm just going to skip ahead here. There's also some others who waded in. Environmental Defense Canada and Oceans Canada and Animal Justice all sort of stepped in. Their arguments were basically rejected, though. So, as set out further below, PMI was too broad to be listed on the list of toxic substances in Schedule 1, and this breadth renders the order both unreasonable and unconstitutional. So, essentially, what the government screwed up on here is they listed too many things. It was too all-encompassing. The governor and council acted outside of their authority and the scheme of the relevant provisions of CEPA in listing the broad category of PMI on Schedule 1. And we'll see why. We'll see the court's reasoning on that. Well, this is important. Similarly, the order exceeded beyond the criminal law power, as there is no reasonable apprehension that all listed PMI are harmful. So, background. It is undisputed that plastics are ubiquitous. And when you're reading this, you might, if you're old like me, you might have flashbacks to The Graduate. I've got one word for you, son. Plastics. This is all going to be about plastics. So it's undisputed that plastics are ubiquitous. Plastics have been around for over 50 years and comprise manufactured items that include final products, as well as components of products that are found in every facet of everyday life and in industry sectors as diverse as packaging, construction, automotive, electronic equipment, textiles, white good, and agriculture. In fact, my shirt is largely made of plastic. The buttons are definitely made of plastic. My cell phone is made of plastic. This microphone is large, lots of plastic. Everything around me pretty much is plastic. Some metal, some glass, but lots and lots of plastic. So, plastic waste management, the disposal and recycling of plastics, and plastic pollution, plastics that remain in the environment and are not disposed of through a waste management system, have been the subject of growing environmental concern and government focus since at least 2016. And I should note, when they say plastic manufactured items, that would include things like cell phones and the microphone and all of that stuff, my shirt. So basically there are some concerns here, but we also have a little bit of scientific study. Now, some of their work was covered by cabinet confidences, which means that the government studied things and got information, but won't tell the public and won't tell the court what that information was, which of course makes it a little difficult to challenge this. It also allows the government to hide things that might have been contrary to their position. So the Deloitte study, so that's one of the studies that they conducted for this, estimated that 29 kilotons of plastic waste, which represented 1% of all plastic waste generated, was released into the environment in Canada in 2016, while 86% was maintained in landfills. That's I think this is kind of good numbers when you think about it, because it's 1% of plastic waste actually makes it into the environment, which means 99% doesn't. Now, 86% ends up in landfills. I don't know what happens to the remainder. Maybe that, I don't know. But 1% doesn't seem like a huge catastrophe to me. But anyway, carrying on. I mean, there are a lot of plastics, so that's the other side of things. The science assessment constituted a review of over 600 scientific publications. It looked at the effects of both macroplastics, plastics greater than 5 millimeters. So, this package here is macroplastic. And microplastics, plastic particles less than or equal to 5 millimeters in size, on the environment and on human health. The science assessment recognized a lack of standardized methods for monitoring microplastics and characterizing the environmental and human health effects of plastic pollution, as well as inconsistencies in the reporting of occurrence and effects data in the scientific literature. It found that macroplastics had been demonstrated to cause physical harm to environmental receptors on an individual level and have the potential to adversely affect habitat integrity, i.e., if a forest is covered in plastic, maybe things don't live in it anymore. And that organisms had been shown to ingest macroplastics and to become entangled in macroplastics. So ingest is they can eat it, and entangled is the standard thing you've seen about, like, cut your pop rings so that it doesn't end up wrapped around a turtle or a baby seal or a seagull or whichever it is. So the report anticipated that the frequency of occurrence of physical effects on individual environmental receptors, i.e., animals mostly here, would continue to increase if current trends continued without mitigation measures, and recommended actions to reduce macroplastics and microplastics that ended up in the environment. The discussion paper, which is another paper that they're looking at here, outlined a proposed framework for managing single-use plastics, which involved grouping single-use plastic items into categories and identifying whether those that were either environmentally problematic or problematic from a value recovery perspective, i.e. a low recycling rate, and which performed essential functions or lacked viable alternatives. So some plastics, even single-use plastics, are pretty important to society. For example, if you go to the hospital, you may get an injection with a single-use plastic syringe. And you really want that to be a single-use syringe, right? That's kind of the ideal. You don't want them reusing those. That's a good thing for single-use. And we don't really have a good alternative to single-use syringes. I mean, maybe they could make them out of glass, but that's not great. So the discussion paper recognized the Government of Canada's commitment to ban or restrict harmful single-use plastic items where warranted and supported by science. This is going to be a problem for them here. And identified 6 plastic items that met the requirements of a ban or a restriction. So these are the things that they recommended banning: plastic checkout bags, stir sticks, 6-pack rings, cutlery, straws, and food service ware made from problematic plastics. Now, I really hate paper straws. They are misery. And quite frankly, I'm doubtful about the value of banning plastic checkout bags, because studies I've read suggest that this actually increases our plastic waste, because people aren't really great at reusing the reusable plastic bags. But regardless, this is what they were looking at. So now you'll note that that's a That's a much narrower category of plastics than all plastic manufactured items, right? All plastic is really broad. So now we're going to talk a little bit about the background here, the amendments to the CEPA. So shortly after the application was heard, Bill S5 received royal assent. As a result of Bill S5, CEPA was amended and Schedule 1 of the list of toxic substances was repealed and reenacted. So they're like, we're canceling this. And then we're doing it again, exactly the same. You kind of wonder why. So upon royal assent of Bill S5, the parties indicated by letter their agreement that the court could and should continue to decide the application, either because it was not moot, which was the applicant's position, that there was still a live controversy, or because the court may exercise its discretion to do so. That was the position of the government, is they said, we think it is moot, but we think that you should hear it anyway. And so the court gave them additional opportunity to prepare submissions on this new bill. Now, why would they hear it anyway? Well, there's some, the court explains that. They note RPUC, so the Responsible Plastic Use Coalition or whatever it was, is also an applicant in the SUP challenge, Petroplastics Corporation versus the Attorney General, which is a new challenge against the new bill. So essentially, after they win on this one, we still don't get any remedy. They got to fight this other case, but that other case is ongoing, and the same parties are involved, right? The government is involved on one side, RPUC is involved on the other, and in Petroplastics, the applicants challenged the regulations on administrative and constitutional grounds. As agreed by the parties, the outcome of this application may have direct practical implications on the Petroplastics proceedings, i.e. they're going to get a ruling, and then the Petroplastics court can consider that ruling, and it'll be precedent that matters. So, the impact on Petroplastics, along with the time and expense already expended on this application, justifies the decision being rendered on the pending issues. So what does that mean? Well, because it's still going to matter, and because they've spent all this money and all this time fighting it, the court is saying, let's not throw that money and time and everything away. You know, I've heard all this evidence. We've had all of this, stuff. Let's get a decision. And that makes sense. This makes perfect sense to me. Okay. Now, there's a whole bunch of evidence, and I'm skipping over all of that because we just don't need to cover it. But we are going to cover, and I just got to find it here. Here we go. All right. So the language of paragraph 3(1)(f) to define PMI, plastic manufactured items, as any items made of plastic formed into a specific physical shape or design during manufacture, and have for their intended use a function or functions dependent in whole or in part on their shape or design. These they can include final products as well as components of products. So what does this encompass? Nearly every plastic item around. I've got a flashlight. This would be an item of plastic formed into a specific physical shape or design, and that's function depends in part on its shape or design, right? It's a convenient shape. Same with your cell phone's case. Same with your keyboard. Same with your mouse. All of these things. So this is so incredibly broad. It covers everything around you. The body panels of your car, the shape of those is highly significant. So the applicants argue that PMI are neither a substance nor a class of substances for the purposes of CEPA, but rather a broad category containing thousands of disparate items. This already seems like it makes sense, right? They assert that the definition of substance in paragraph 3(1)(f) of CEPA is in the singular. Thus, it only contemplates single specific items, i.e. fishing nets or six-pack rings. So they're basically saying you can't control all plastic, federal government, but you can maybe target certain specific items made of plastic. The respondents, so the government, concedes that they're not asserting that PMI is a class of substances. They accept that PMI can vary in their form and shape, chemical composition, chemical structure, and physicochemical properties, and are used for a variety of purposes. Because again, this is everything, right? Rather, they contend that PMI satisfies the definition of a substance, as substance is intended to be in the plural. And you might think, how is it that when they use the singular form of the word, substance, that would mean plural, substances? So they refer to the Interpretation Act, which is an important set of laws. The Interpretation Act is something you should read if you are doing law. And because the Interpretation Act sets out how a ton of other things are to be interpreted. So as an example, when a particular piece of legislation says that you need 3 clear days in between 2 dates, well, how do you measure that? Do you include those 2 dates? Do you exclude them? What about if there's a weekend? What about if there's a holiday? Those kinds of things. And so the Interpretation Act is the thing that answers all of those questions. And it states that words in the singular include the plural, and words in the plural include the singular. So, and the French text, which they assert that indicates that this paragraph was intended to apply in the plural. So because of the Interpretation Act, if it says, a dog is a forbidden item, then dogs are forbidden as well. And so this is kind of a technical argument, but it matters. So this is kind of the baseline here. And you can see that there's a lot of this that I just can't go through because it's going to be tremendously lengthy if we do. The basic principle of toxicity for chemicals is that all chemical substances have the potential to be toxic. However, for a chemical substance to be toxic, it must be administered to an organism or enter the environment at a rate or dose that causes a high enough concentration to trigger a harmful effect. I.e., lots of, just about everything, the old line is that the dose makes the poison. And, water, we normally consider water to be fairly healthy. It is possible to drink too much water and die. And it's also possible to just drown in it, right? So often there's questions of just, how much will cause some sort of problem. Lead contamination. If the lead is like 1 part per a billion billionths, of water, then we're not talking about a harmful effect. But if it's, if there's a lot of lead in the water, then that's going to be a big issue. In this instance, the reverse logic appears to be applied. All PMI are identified as toxic because they're made of plastic, and because all plastic is deemed to have the potential to become plastic pollution. The conclusion is devoid of consideration of the extreme variability in the shape and type of plastic used to make items and plastic's variable properties, whether the plastic item is conducive to causing harm to animals from strangulation or suffocation, or to the environment because of effects such as rafting, etc. So, if we go back to our examples here, like a plastic bag, an animal can get that stuck over its head and suffocate. But it's going to have a really hard time having the same effect with this flashlight. You can't get, no matter how much I try, I just can't get this plastic flashlight over my head to suffocate myself. It just isn't going to work. Plastic dice are going to have different issues than a plastic car panel, all of these things, right? So, as noted earlier, the RIAS refers to only a small number of specific items, ropes, nets, cable ties, plastic bags, packaging rings, as being reported in the scientific literature to exhibit adverse effects on some animals as a result of entanglement or ingestion. Fishing nets are particularly bad because, of course, they're designed to be entangling in their intended purpose, and then a piece of a fishing net continues to be entangling when it gets out there. So these are things that animals, it's harmful when they eat or when they get around their necks or whatever else. In my view, the government in council could not, or the governor in council could not have been satisfied from this evidence that all PMI are toxic, i.e., there's just too many kinds of plastic. Government, in the context of considering regulations to prohibit SUP, published findings in the discussion paper indicating that not all PMI are harmful. So, the report excerpted below indicated that several types of single-use plastics, other bags, for example, garbage, multi-packaging, disposable personal care items, so for instance, tampon applicators, etc., contact lenses and packaging, and hot and cold drink cups and lids that were not considered to be environmentally problematic because they were either not prevalent, I mean, there's not that many contact lenses out there, or were not known or suspected to cause environmental harm. Most trash bags end up in landfills, right? Garbage bags have a tendency to end up in the garbage by their use. However, despite recognition that these items are not environmentally problematic, they're included in the category of plastic manufactured items that are toxic. So, all right. Even if the statement that all plastic manufactured items have the potential to become plastic pollution is taken on its face, the evidence available to the GIC did not support the finding that all plastic manufactured items are toxic. So because of that, this is going to cause some problems for the government. Now, again, we're not covering everything here. There was some issues as to whether or not they had to do a consultation. We're going to skip over that. However, we are going to look at, is the order unconstitutional as being outside the federal criminal law power? Now, the criminal law power is something that the federal government has used to try to extend its power in various ways for a long time, and sometimes successfully. So, for example, the firearms reference case determined that firearms regulation was a valid use of the federal criminal law power. But we also have cases where, for instance, they determined that margarine is not a valid use of the federal criminal law power. So, yeah. So, in Hydro-Quebec, the Supreme Court of Canada confirmed that the protection of the environment through prohibitions against toxic substances is a wholly legitimate public objective in the exercise of the criminal law power. It is a public purpose sufficient to support a criminal prohibition and that does not rely on any of the other traditional purposes of criminal law, that being health, security, public order, etc. So as an example of a valid use of this power, they could, for instance, set it up as a crime, a criminal penalty to dump toxic chemicals into the environment. So that would be allowable as part of this. But that doesn't mean that they can just say everything related to the environment, or so long as you can just point vaguely to an environmental concern, that's going to be good enough to justify things. Because the court was very concerned that that would be exactly what the government would do. And so, this is going to be a potential problem here. So they get to the second part of this question, which is the order ultra vires federal jurisdiction? Ultra vires is Latin, and I don't know why we still use it, but it basically means, is it outside the federal jurisdiction? Are they using powers that don't belong to them? So as stated earlier, for legislation to fall within the criminal law power, it must contain a criminal law purpose, a prohibition, and be accompanied by a penalty. Because if it doesn't have a penalty, it's not criminal law. The focus of the challenge here is to whether the order could be characterized as providing a criminal law purpose. As set out in Attorney General for Ontario and reciprocal insurers, the machinery of criminal law cannot be used to assume control over something that is not within Parliament's authority. This is the big concern that always exists with these kinds of cases, is Parliament just taking power for itself? Is the federal government trampling on the rights of the provinces? So further, Parliament may not assume control over an activity that is not in itself harmful or dangerous in order to prevent the harmful or dangerous forms of the activity. And they cite the firearms reference case, which I'm going to skip over here because that's a whole other kettle of fish, and I should probably cover that case in some detail another time. The applicants assert that, so the government here argues that there are limits, and they're saying, we're only going to go as far as we need to go. You can trust us, which the applicants say that this is nothing more than a trust me argument, with the order permitting the governor and council to assume control over all plastic manufactured items on the trust that regulations will be restricted to only those plastic manufactured items that create a real risk to the environment. They contend that they should not have to wait until regulations are enacted to challenge an unconstitutional order. I agree. So the court says that is correct. So to employ criminal law, what is being restricted has to be actually dangerous, i.e. there needs to be a harm. Otherwise, the restriction amounts to nothing more than economic regulation, which does not satisfy the criminal law purpose test. In fact, this is exactly what the government is not allowed to do with the criminal law power. They're not allowed to engage in economic regulation. That's a power that belongs to the provinces. So, as set out earlier, not every item within plastic manufactured items has the potential to create a reasonable apprehension of harm. This is different from examples such as lead and carbon dioxide given by the respondents, which are substances that may not be inherently toxic, but which may have aspects or uses that are toxic. In this case, the substance PMI is a broad category of items that include items with no reasonable apprehension of environmental harm. The broad and all-encompassing nature of the category of PMI poses a threat to the balance of federalism, as it does not restrict regulation to only those PMI that truly have the potential to cause harm to the government. So they say Section 93, which is a limitation section, is insufficient to maintain the order within the criminal law power. The order is ultra vires the criminal law power, and therefore it is not a power that the federal government holds. This is unconstitutional. Now, I'm skipping over this POG argument, which is peace, order, and good government. That was the argument brought by animal justice and various ecological groups. Court doesn't give it a whole lot of time. So, for all of these reasons, I find the order and its corresponding listing of PMI on Schedule 1 of the list of toxic substances to be both unreasonable and unconstitutional. Now, very briefly, we'll look at some of the remedies, because the applicants basically said that they want this to be thrown out retroactively such that it would have impacts on how Bill S5 is applied now. And the court refuses to do this. The court says, listen, I can't pre-decide your next case. I can't strike down Bill S5 because that wasn't the topic of this case. So ultimately they say this was an unconstitutional law and it doesn't apply and all of that. But the practical impact for right now is nothing. There's no change to right now in terms of what plastics can and can't be brought in. That's for a future case. And this is going to be a big deal for that future case. This is going to be a big deal when that case gets decided. But it doesn't change anything today. So all of those news articles that were like, oh yeah, the plastic bag ban was struck down. Kind of. Not yet, really. But it might be in future if the next court upholds this decision. Now, the government has said that they want to appeal this, and there's various environmental groups really pressuring them to appeal. So we'll see what happens. But for right now, this is another case of the federal government trying to take powers that don't belong to them, trying to exercise authority that properly belongs to the provinces and getting smacked down on it. This is something that's happened a few times recently, so we'll see if that trend continues. Anyway, a lot of people wanted me to explain this case, and I hope I did a good job, and I hope I kept it to... I hope people are still awake. If you are, please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level, Canada's National Farms Association, the CCFR, the Canadian Shooting Sports Association, and Lembas for the Elf, as well as at the $20 level, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Here's a Coin Legal Witcher, Cameron Johnson, Andrew Elsich, and Vicky and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.